In this video, I just want to explain to you the importance of timing. If you have a particular employment-related problem or issue that's concerning to you, I've come across a situation there, or in fact 3 situations in the last 12 to 18 months, and in each case the employee made a major mistake, in my view, in their timing. Basically, what I'm referring to is, firstly, a situation where an employee was in a job for a long time and difficulties arose with the employer, and eventually the relationship broke down to the point where the employee, quit the job, just quit, and decided that they were going to bring a claim for constructive dismissal. And they came to me then, and I assisted them with that claim. However, had they come to me before they resigned, I would have advised them differently, completely differently. But unfortunately, they only came to me after they resigned. This was a person, an employee, who was in the job for quite a while and would have had a fair old redundancy entitlement built up. So in those circumstances, leaving the job without getting advice first is, in my view, a mistake. I know it's very, very frustrating for you as an employee if your employer is treating you very harshly, very unfairly, and is basically, ignoring the law to a great extent. But you need to be very, very careful. There's no point in winning a battle and losing a war. In other words, if you walk out of the job, you have a constructive dismissal situation, and the burden of proof is on you to prove your case, which is far more difficult to do than if the employer dismissed you. But in any event, even if you're going to bring a claim for constructive dismissal, there are certain steps that you should take before you leave. For example, you should exhaust as best you can the internal procedure in the workplace to canvass any grievance that you have. Now, this may be a completely futile exercise. It may be unsuccessful, but that's not the point. The point is that you are actually setting up a chain of evidence demonstrating that you have tried everything to resolve the problem, and that you have behaved professionally and reasonably. And the whole question of reasonableness is critical in constructive dismissal cases. Did the employer act reasonably? Did the employee act reasonably? And the employee is going to have a better chance of winning a case if they act reasonably, or at least appear to act reasonably, and take every step that they can to sort out the problem to begin with. After that, if it's not sorted out, by all means bring a claim down for constructive dismissal. But when you go along to the Workplace Relations Commission, you've got some documentation, you've got some evidence that you actually tried to resolve the problem. You brought the problem to the attention of the employer. You gave him or her the opportunity to put it right, what you say was wrong, and they didn't do that. The second instance of a timing situation occurred in relation to somebody negotiating an exit out of the job. Again, they were somebody who had worked in the job for quite a number of years and would have had a redundancy entitlement built up as well. In that situation, they signed an agreement to negotiate, or a negotiated exit, and left the job. And some months afterwards then, they decided that they wanted to bring a claim, a constructive, or not a constructive dismissal claim, a number of different claims against the employer for various alleged breaches of the employment contract over a period of time. The difficulty was they had signed this negotiated exit, and basically this signed agreement that they signed promised or undertook, they gave an undertaking not to bring any claims arising from the employment. So in return for signing the agreement and getting a few bob, getting a settlement, getting a negotiated exit, they signed away their right or their entitlement and provided a waiver to the employer. They signed away the right to bring any further claims. That was it, game, set and match. Once they took the money and signed the contract or signed the waiver and indemnity, that was it. Now, they could have got advice before they did that. But again, it's too late coming to a solicitor after you've done that, looking to bring a claim for whatever. So again, that's the second instance of timing being absolutely critical. The third one is in relation to an employee who brought a number of claims to the Workplace Relations Commission about working time, working hours, excessive hours, not getting rest breaks, minimum wage, and so on. The bottom line, all of the claims were slightly outside the 6-month time period. So again, it's a timing issue. The Workplace Relations Commission adjudicator simply said at the outset that they were not in a position to hear the complaints because they simply didn't have jurisdiction. The legislation provided for bringing these complaints within 6 months. Now, it could be 12 months in exceptional circumstances, but no reasons were put forward to show or demonstrate these exceptional circumstances which would allow the claims to be brought within 12 months. So in that situation, all of the claims that that employee brought were thrown out simply because the Workplace Relations Commission adjudicator decided that he did not have jurisdiction to hear the claims. So timing is critical, in employment-related issues, in life generally, but certainly, get your advice first before you take action, and then, having weighed up all of the facts, having weighed up all of the advice or opinion that you've got, then make your decision by all means and leave your job if you want to, if that's what you're determined to do, but do so in the full knowledge of all of the facts. Don't shoot first and ask questions later, because it's not going to pay off for you in an employment law situation. I hope you find this useful. If you do, you might just click the like button below the video.